All right, now let's discuss this further, the possible impact of this. We're now joined via Zoom by legal analyst, Advocate Romeo Nthambeleni. Advocate, thank you so much for your time this afternoon. So what is the possible impact of, these developments on the proceedings themselves?
Okay, good afternoon, Unati, to you and the viewers. Look, it's very clear that if we are proceeding this way, there are chances that the entire Section 194 inquiry can collapse on the basis of the lack of legal representation for the public protector. So I think that is what is at stake now at the moment, to answer directly that question that you're asking, Unati, as to what will happen.
And she also wants, and of course that is Advocate Mkhwebane, she also wants the inquiry to be postponed, until the matter has been resolved, to your point, given what the consequences are. How much of, this decision is about funds in terms of her wanting this to be postponed? How much of her utterances is actually about funds, especially if you consider that she, does have about, 6 months left of her 7-year term?
Yeah, it's quite, correct. A term lapses in October. And then, the issue relating to fees, is important so that the inquiry can be able to complete its work. I noted that the Department of Justice offered 20 million rands, and that 20 million rands could not actually ameliorate the exorbitant, fees that were, incurred, throughout these proceedings, because the proceedings were somewhat prolonged, and maybe to also look at other issues. The applications that were coming, interlocutory applications, also affected the period of the sitting of these proceedings, and that's why we are finding ourselves where we are, Unati.
You just gone back to your original statement about having to see that this entire inquiry could possibly collapse. I mean, Advocate Mkhwebane also insisting, that she has every right to be represented by a representative of her choice as per the Constitutional Court's ruling. So what then would be the likely recourse for her should the inquiry insist on continuing with the proceedings while she doesn't have legal representation?
Yeah, it's an important question. As we've already seen, she can approach court, and ask that the court rule in her favor that the entire inquiry should actually not proceed on the basis that she doesn't have any legal representation. And then in that application, she is going to show prejudice that she's going to suffer. And what she's going to use on that is that judgment that supports her from the Constitutional Court, which says that she must have a legal representation of her choice. And she is making a point in arguing that the inquiry is not of her own making. And then, she's actually suffering occupational hazard, and she cannot be expected to pay the cost herself. And I think that argument can win favor, in court.
So, let's just go back to what we've been hearing, during the inquiry, just some of your analysis of what is coming out. Advocate Mkhwebane always maintaining that this impeachment, these proceedings were a witch hunt against her, even calling them racist at some point. Give us your review, just in terms of what the evidence that has been led by Advocate Dali Mpofu largely related to, and how that could possibly act in her favor or not.
Yeah, look, what came out in her evidence, which was being led, is obviously the issue that she is being targeted, and then she has touched the untouchables. She's not incompetent, and then this inquiry is not about her fitness to actually hold office, but is that that she has touched the people that she's not supposed to touch as a public protector. But all that having been said by her remains hearsay evidence until the evidence leader confront her with the evidence. That is the important part, which I'm ultimately waiting for, to say, here are the reports that were reviewed by the courts and they were set aside, and the courts made a decision that you are not a competent person as a public protector. What do you say to that? That is, very, very, very much important. What I'll want to hear once the evidence is being brought by evidence leaders confronting the, statements that she has made, because a statement that has been made without being substantiated by evidence remains such. It remains hearsay evidence. So what is important is what the evidence leader have, as a case against her. And then if she can answer that, then we could somewhat be going somewhere in terms of the evidence that the evidence leader will present.
What is the likelihood of that happening, where we do see, some of those pertinent questions that you allude to, where the evidence is clearly lacking, being answered to, and having this inquiry move ahead?
Yeah, it appears from from the sitting of the inquiry up until this point, there have been even further judgments of the courts that actually set aside the reports that the public protector has made, and there's also a flawed perspective from the public protector that she must be equated to to a judge in the High Court, and that shows the very same issues of the understanding of the Office of the Public Protector as a Chapter 9 institution and its powers. And we have got judgments of the Constitutional Court relating to the powers of the Public Protector and how it operates as a Chapter 9 institution. So to equate it to an office of a judge in the High Court, it's a flawed perspective. And once the evidence leaders have provided the evidence, we will want to actually see on her side how is she going to rebut the evidence that she has been confronted with. That is the heart of the inquiry, as to how does she deal with the evidence that will be brought by the evidence leaders confronting her about the judgments that were given by court, and then the recommendations that were made by court to recommend the LPC that she must be removed as an advocate of the High Court, the decisions of the Constitutional Courts that ordered her to pay personal costs in some of these matters, and also extending the lines of authority when you are not supposed to act within a particular framework of the authority in the office as a Chapter 9 institution. Those are key questions that must be answered by the public protector in the inquiry on that.
Advocate Nthambeleni, thank you so much for your time this afternoon. Really do appreciate your analysis. Legal analyst there, Advocate Romeo Nthambeleni.